The Supreme Court's 9-0 unanimous decision in United States versus Martin didn't just give one family their day in court. It exposed a decades-old legal loophole that's been protecting government agencies from accountability, and the implications go far beyond wronghouse raids. Legal scholars are calling this the most significant government liability ruling in 30 years. But what they're not telling you is how this decision reveals a systematic failure in how federal law enforcement operates. Before we dive into the legal earthquake that just hit Washington, make sure you hit that subscribe button. The discretionary function, loophole explained. Let's talk about something that sounds boring but is actually terrifying. The Federal Tort Claims Act was passed in 1946 to finally allow American citizens to sue their own government for wrongdoing. Before this law, the government had absolute sovereign immunity, meaning you literally could not sue federal agencies no matter what they did to you. Congress supposedly opened the courthouse doors with the FTCA, but they installed 13 different exceptions that slam those doors right back in your face. The discretionary function exception was supposed to protect high-level policy decisions. Between 1990 and 2020, federal courts dismissed over 15,000 lawsuits using the discretionary function exception alone. A 2019 study by the Federal Judicial Center found that government attorneys invoke the discretionary function exception in 82% of FTCA cases, and courts accept that argument in 61% of those cases. That means nearly 2/3 of families who experience government wrongdoing are told there's no remedy because the agent made a discretionary choice. What the Supreme Court just did is call out this abuse. Justice Gorsuch's opinion essentially says lower courts have been letting the government get away with conflating policy decisions with negligent execution. And the reason this matters goes way beyond raids. It affects every interaction you might have with federal agencies. The federal agencies protected by this loophole. Here's what nobody's connecting. This discretionary function exception doesn't just protect the FBI or ATF. It shields every federal agency that touches your life. The IRS has used it to defend against wrongful levy and seizure claims. Between 2015 and 2023, the IRS faced 4,200 lawsuits alleging improper asset seizure. Using the discretionary function exception, they got 68% of those cases dismissed before trial. The TSA has invoked discretionary function immunity in cases involving wrongful searches, detention, and property damage. The VA has used this exception to defend against medical malpractice claims, arguing that treatment decisions made by VA doctors are discretionary functions. Between 2010 and 2020, veterans filed over 9,000 medical malpractice claims against the VA, and approximately 5,400 were dismissed using various FTCA exceptions, including discretionary function. Immigration and Customs Enforcement has deployed this defense in wrongful detention and deportation cases. This ruling doesn't just affect law enforcement raids. It potentially opens the door for accountability across the entire federal bureaucracy. The legal standard that courts misapplied. The Supreme Court's decision reveals something critical that lower courts have been getting wrong for decades. There's a specific two-part test that's supposed to determine whether the discretionary function exception applies, and it comes from a 1988 case called Berkowitz versus United States. First, the court must ask whether the conduct involves an element of judgment or choice. If there's a mandatory federal policy, regulation, or statute that dictates the action, then it's not discretionary. Second, even if there is judgment involved, the court must ask whether that judgment is the kind of judgment that the discretionary function exception was designed to shield, meaning judgment grounded in considerations of public policy. In the Martin case, the 11th Circuit never even applied this two-part test properly. The Supreme Court basically said the lower court skipped the entire analysis. Federal law enforcement agencies have detailed operations manuals, mandatory training requirements, and specific protocols for executing search warrants. When agents deviate from those mandatory procedures, that's not discretionary decision-making, that's negligence. A 2020 review of FBI operational guidelines shows There are at least 47 mandatory procedural steps required before executing a high-risk search warrant, including independent address verification, surveillance confirmation, and supervisory approval. The Supreme Court just confirmed that absurdity, and now every federal agency has to reckon with this new legal reality. The circuit split that forced Supreme Court intervention. Here's something that legal nerds have been watching for years. Different federal circuit courts had completely different interpretations of how the discretionary function exception works, creating what lawyers call a circuit split. The Ninth Circuit, which covers the West Coast, had been relatively strict in limiting discretionary function immunity. The 11th Circuit, covering the Southeast, had been extremely permissive, essentially granting immunity whenever any judgment was involved. Between 2015 and 2023, plaintiffs in the Ninth Circuit won summary judgment against the government in FTCA cases 31% of the time, while plaintiffs in the 11th Circuit won only 14% of the time. When circuit courts are this divided, the Supreme Court typically steps in to establish a uniform national standard, the institutional resistance to accountability. Now let's talk about why the government fought this case so aggressively. It's not just about money. It's about maintaining a system where federal agencies face minimal consequences for mistakes. In fiscal year 2023, the government spent over $180 million defending FTCA lawsuits and paid out approximately $2.4 billion in settlements and judgments. Government agencies don't want accountability because accountability is expensive. The Martin decision means agencies can no longer rely on discretionary function immunity as an automatic shield. They'll actually have to review whether their agents followed mandatory procedures, whether policies were violated, and whether negligence occurred. The constitutional accountability gap. There's a fundamental problem in American law that this Supreme Court decision exposes but doesn't fully solve. Our Constitution guarantees certain rights. But what happens when the government violates those rights and you can't sue? The Fifth Amendment guarantees due process before the government can deprive you of life, liberty, or property. But if discretionary function immunity shields the government from liability when they violate due process, what's the point of the guarantee? This is what legal scholars call the constitutional accountability gap. Why legal gun owners should care about legal reform. Here's the specific angle that affects you if you're a Second Amendment advocate. Federal agencies like the ATF operate with broad, discretionary authority to interpret regulations, conduct investigations, and execute enforcement actions. But when the ATF makes mistakes, raids the wrong person, or misapplies their own regulations, they've been hiding behind the discretionary function exception to avoid liability. There have been multiple cases where ATF agents conducted investigations based on misinterpreted purchase records, flagged legal buyers as straw purchasers, and initiated criminal referrals that ruined lives before being corrected. The Supreme Court's unanimous decision in United States versus Martin represents the most significant limitation on federal immunity in a generation. Legal reform groups are pushing for congressional action to narrow FTCA exceptions further. What happens next depends on public attention and political pressure. Subscribe so you're informed when these cases develop. Like this video and drop a comment with your thoughts. Share this with anyone concerned about federal overreach, gun rights, or constitutional accountability.